So there is a large and I would say growing literature that I would describe as law and quadratic voting, the application of quadratic voting to various areas of legal decision making. This literature obviously characterized by a lot of papers that Eric and Glenn have written together, but not entirely by just those papers. And so they've surveyed a variety of different areas of law where they think quadratic voting could be usefully applied: bankruptcy and reorganization, corporate governance, and then the original Posner and Weil paper is even broader and talks about sort of democratic decision-making more generally, or decision about projects in the public sphere, and then also agency decision-making as well. And I would say that sort of the general message of this literature is that quadratic voting is basically useful everywhere and should be applied all over the place. So if I were to come here and say that I think that quadratic voting is useful in patent policy and should be used for patent policy, I don't think that would be considered too earth-shaking. So I want to try to make a slightly stronger claim, which is that I think that quadratic voting is perhaps more useful in the sphere of patent policy and making patent law, or at least just as useful as it would be anywhere else that we could think of in public choice and decision making, because the alternative mechanisms for deciding on patent policies are so limited and so fraught with error. So as a comparative matter, I think quadratic voting looks especially good in the realm of patent law, and so this is my sort of attempt to contribute to this literature on law and quadratic voting in a way where I think that quadratic voting can make even perhaps its strongest impact. Okay, so sort of a quick overview of the difficulties in formulating sound or useful patent policy more generally. So first of all, the thing that everyone sort of talks about, I guess the headline point, is the technical complexity involved in adjudicating which patents are valid, what things are infringed, what the rules should be about all of that. So patents these days especially are over increasingly complicated technology, and the people who are dealing with them do not have a lot of expertise in that technology. Certainly no member of Congress knows what they're doing when faced with a patent or with the technology that underlies that patent. But in addition, all patent trials are adjudicated by generalist judges who don't have experience in these areas of technology, typically don't have technical degrees. And even when those cases get forwarded up to the Federal Circuit Court of Appeals, which is allegedly an expert court specifically designed to hear patent cases, the judges of the Federal Circuit really don't understand the technology either. There is no one on the Federal Circuit who has an advanced degree in any area of technology. There are 2 people who have bachelor's degrees in a STEM field. Mostly what they're good at is sort of making doctrine dance, which is good if you're a lawyer who just loves to watch legal doctrine, not so good if you actually care about the sound formulation of policy. So there just isn't a lot of expertise. But I actually think that these technical issues are by no stretch the most important phenomenon in patent law and in the difficulty of determining how to formulate sound policy. To my mind, the economic complexity is really the much bigger problem. And the biggest issue here is that it's very, very hard to figure out the effect of patent policy on innovation or on any of the other features of innovation that we might care about. So determining the elasticity of innovation with respect to patent policy is extraordinarily hard. There have been sort of excellent efforts in a variety of areas, but they're always very limited. You know, you find a natural experiment here or a natural experiment there, and beyond that, it's really hard to know exactly what to do. And for that matter, determining the deadweight loss of various caused by property rights and over various types of technologies is also exceedingly difficult. And the courts that adjudicate these questions, or as I will talk about later, the agencies, Congress, just poorly equipped to answer these very tricky economic questions, which rely on dynamic interplay between firm decision making and individual consumer purchasing action, and so on and so forth. Thirdly, even if you could somehow overcome those first 2 difficulties, the rules are different in every industry, and they're enormously different, partly because the upfront cost to innovation can vary enormously widely. If you want to develop a new drug, that's a several $100 million enterprise to run clinical trials and the like. If you want to develop a new piece of software, that might just be a couple of $1,000s to have some good coder sit down and quickly write an app. Technology changes very quickly in these industries. Patents are written very differently in these industries. Some patents are very broad. I think people think in software, patents are typically written very broad fashion. In biotech, they're written often much more narrowly. And so the effects in one industry are not necessarily replicated in another industry. That means that if you find a moment for a terrific natural experiment and a really good economist writes a terrific paper about the effects of a change in the patent law on one industry in the year 2000, it's not clear that that paper tells you anything about what patent law will do in a different industry in the year 2016. So even if we could solve problems 1 and 2, we have problem number 3. And then lastly, we have widely disaggregated competing interests when it comes to patent law. There are multiple different parties who find themselves on one side or another of these issues, and those allegiances often shift from time to time and from case to case, from issue to issue. So on the one hand, we have upstream producers. So I think of upstream producers as the people sort of doing the basic research, creating the sort of foundational building blocks for what will become patented technology, not necessarily university science researchers, but the person developing the better semiconductor as opposed to the person who's selling the iPhone, let's say, or the individual who is building the mathematical molecule to design the new drug as opposed to the person who is actually selling and marketing that drug to consumers. Those upstream producers are generally, but not always, patent owners. They are generally, but not always, pro-IP. Sometimes their work depends on the ability to license IP from other people as well. Then, of course, there are downstream producers, the person who takes the semiconductors manufactured elsewhere and turns them into the iPhone, or takes the molecule and turns it into the drug. Those people are often, but not always, patent licensees. And they often, but not always, favor sort of weaker IP protections. But again, there are dynamic effects here also because they care about the development of new products, which they can then bring to market and sell. And I guess I should say, and I'll say more about this later, a lot of these parties, the sort of quote unquote, the side that they're on, where their preferences lie and how intense those preferences are, can change dramatically over time as the company evolves, as their business model evolves, and as the industry evolves more generally. So just take Microsoft, for example. When Microsoft started out, Microsoft was a sort of very stridently anti-intellectual property company. They were competing against entrenched players, and they were arguing that software patents shouldn't be allowed because Microsoft Business relied on sort of entering, despite the fact that it might be infringing intellectual property that belonged to others. Then there was an extraordinarily long middle period, maybe 25 years, where Microsoft was doing some innovation, creating patents of its own that it was licensing to other people and collecting royalties on. It was also a target for lawsuits. Once your market capitalization gets above a certain level, you get sued a lot, particularly in high-tech industries. And Microsoft actually did not know whether they were pro-patent or anti-patent. The company had a kind of an officially neutral position. And now recently, Microsoft has decided that it is strongly pro-patent. As it's matured in the industry and as it's collected a lot of IP, now its preference is to use that IP to solidify its market position, and it thinks it has more to gain from stronger IP rights than it has to lose. And then, of course, lastly, there are consumers, the most disaggregated of these groups. And consumers' interests are divergent as well, and it depends a lot on the extent to which they are subject to deadweight loss from intellectual property rights, or the extent to which they desire or are dependent on new innovation. So if you're someone who has excellent health insurance and you just want to sort of grow old and live forever, you might really be in favor of strong patent protection because it might be that your costs are covered at least, or they're spread across a large number of people, and so you're not going to face significant upfront costs for more drugs and better drugs. On the other hand, you want the pharmaceutical industry to innovate very aggressively so that they'll create whatever it is that will save your life when you're 85 years old. For other people, it might be a very different story. So consumers have divided interests, and of course, these interests impact them quite substantially. Some of them have very strong preferences in one direction or another, depending on the particular products that they might be using, and the question of how subject they are to deadweight loss, and the issue of whether the products that currently exist are fulfilling whatever their needs are and their interests, or whether they have preferences for things that have not yet been developed but that they would like to see developed. Okay. So now I want to talk about the institutional mechanisms that we have or conceivably could have in the modern framework for adjudicating patent questions. First and foremost, there are the courts, who are the primary expositors of patent law right now. That's where the action is. And for lawyers, it's perfectly natural that the courts would get to decide all these questions. So obviously, the courts have significant trouble with complicated technology. I'm just sort of going to glaze over that because, again, I don't think that's even close to the largest problem that courts face. I think that the largest problem is that courts just don't have any conception of the economic effects of their changes in the law on on innovation or the development of new technologies in response to judicial decisions. They have no way of gauging elasticity of innovation. They just don't know. They don't know what the effects of their decisions to strengthen or weaken patents will be on even the industry in which those patents are most clearly applicable, much less in other industries. So, a software case could come before the court, and even if the court managed to understand the effect of that case on the software industry, which I think is very, very uncommon, the decision that the court hands down will have general effect, because patent cases, by and large, are sort of trans technology. They are not limited to any given field. This is a law that's meant to cover all areas of innovative behavior. So a decision about a high technology case in a particular circumstance could easily affect biotechnology cases somewhere else, and the court has no way of coping with that. There's no mechanism for that within the typical structure. They can get amicus briefs from companies that are interested in filing them, but it's not a good way to measure preferences. It's not a good way to measure intensities, especially. And then, of course, they have no sense of the deadweight loss from patents. I think courts have this idea that more patents equals higher prices, and that's bad for consumers. But that's not necessarily true either. It really depends on the market that the innovation is targeting. It depends on the access to insurance and to two-part pricing that the people who are purchasing that technology might have. It depends on the level of wealth of those people, and so forth, and so forth and so on. And the courts don't have any way of calculating that or thinking about it, other than in the most general sense either. And so I would say that the combination of technical and economic issues make these cases among the most difficult for courts to conceivably decide, even in a realm in which we have lots and lots of courts out there weighing in on economic and technical issues that they're not very well equipped to handle. I think that these are plausibly the most difficult for those courts to be able to manage. And as evidence for this, I could cite a whole lot of scholarly research, but instead I'm going to cite Eric speaking at the law school's graduation from 2 years ago, in which he said there are hard problems and then there are impossible problems. And the hard problem was some canonical legal thing about federal courts and jurisdiction, and the impossible problem was a patent problem. So I consider that more of an authority than all the rest of the scholarly literature that I've read. All right, so if not courts, then what about administrative agencies? So this is sort of the second option. Now, Eric and Glenn, in their original 2013 paper, talk about quadratic voting as superior to cost-benefit analysis, which is what agencies are mostly using, of course. And I think those points are right. And I guess what I want to say about this is that doing cost-benefit analysis of patent law is again, probably more difficult, at least as difficult, but probably more difficult than doing cost-benefit analysis of essentially any other area of law and policy. So the Patent and Trademark Office, which is the main agency, doesn't typically have rulemaking authority. The EPA is making our environmental rules, but it's not the Patent and Trademark Office that's making patent rules. It's the courts. Then again, we could change that. We could imagine that. We could imagine the PTO using cost-benefit analysis to try to understand the effects of patent law decisions, and even they could do it at a much more fine-grained level than courts do. Okay. But here, and so, there are some reasons to be optimistic, I suppose. Patents usually concern things that are traded in markets, so there could be revealed preferences that the Patent and Trademark Office could draw upon to gather information about whether or not they should make this or that tweak to the patent law. Okay, here are the problems. It's hard to gauge willingness to pay for things that have not yet been created. So they're going to have to go out and find out sort of what are consumers' preferences over technologies or products that just don't exist yet. And so that's going to be a relatively fraught exercise. All of the relevant information on the producer side, all the information about whether this company is licensing to that company, what the inflows and outflows of money look like, what the relationships between firms dealing in the same technology subfield and negotiating deals over intellectual property look like, all of that is secret and held from public view. That's essential information because you want to know, if you're the Patent and Trademark Office, if we made software patents stronger, would that, on the one hand, have the effect of encouraging innovation in the software industry, because now people have an incentive to produce many more software innovations? Or would that decrease innovation in the software industry? Because now, if you want to innovate through software, you have to take licenses to a much broader range of intellectual property rights. You have to negotiate deals, or you are at risk of being held up or being sort of effectively taxed in the large amount of damages. all of that information is secret and proprietary. The courts or the agencies just don't have any way of getting at what those type of transactions look like, which companies are on which side of the equation. And this is sort of why I bring up the Microsoft example. We often don't know whether a company is a net licensor or licensee of intellectual property until that company appears in front of Congress and makes a public statement. And there are a couple companies that do that, like Google. But there are lots of other companies where, for years and years and years, that we just don't have any information on that point one way or another. So there's a whole lot of secret information that the agencies just don't have any good way of accessing that's essential to this question of what we want the shape of patent policy to look like. And I guess I would just say, the source that people draw upon, if you look at research that's been done on these points, what people are looking at basically are reported cases. There's a court that adjudicated a patent dispute. The number of reported cases is probably smaller than the number of licenses that are taken by 2 to 4 orders of magnitude. And again, that enormous range of uncertainty is due to the fact that we simply don't know how much licensing behavior is going on out there. But there's no reason to believe that the public information we have is representative or that it really provides much of an indication of what's actually going on in these industries. Okay, let's see here. All right, so more about agencies. In addition, they have all the same problems that courts do about determining elasticity of innovation in response to changes in law. There's a relative absence of really good natural experiments, really good empirical research that's been done out there. But as I said, even if there were lots of really good research, I'm not sure we'd know what to do with it. There are people. Heidi Williams has done really interesting work with drugs and biotech. Petra Moser has looked at all sorts of interesting influences. Petra Moser has this great line of research about the effect of patents on the sewing machine and various other sort of industries in response to particular changes in the law from 100 years ago. And it's really sort of terrific stuff for telling you kind of generally at a very high level of abstraction what patents are doing. But I think you'd be very foolish to take anything we learned about the sewing machine industry from 100 years ago and try to apply it to semiconductors or biotech today. And then finally, this last problem is industry by industry variance again. We just don't know, once we've learned one thing in one place, we don't know whether it applies in another place or not. Okay, so the end result is that cost-benefit analysis is just a lot more challenging when it comes to patents than it is when it comes to other things where the dynamic effects are simpler and more of the necessary information is public and has been the study of better research. When the EPA is trying to figure out what are the costs and benefits of regulating carbon monoxide, there's just a lot more information, and the dynamic effects it has to worry about when it imposes a regulation are a lot simpler to model than when the Patent and Trademark Office is trying to do the same thing about a rule that would make it easier to get an injunction for infringing someone's software patent. It's just a lot simpler. And that shows in the results, by the way. The Patent and Trademark Office has lately started promulgating some important rules, and it started issuing cost-benefit analyses to accompany those rules. And of course, some of its failures are growing pains, but if you read those rules, you'll see that the Patent and Trademark Office just doesn't have the first idea about how to start digging into this question of costs and benefits of patents. So the agency here, I think, is even more hamstrung than an agency in a typical realm. Okay, lastly, there's Congress. We could have, of course, turned to Congress. So there are all these other typical problems with Congress that make quadratic voting simpler. I will not go over that, differences in preferences. But even beyond that, I think the thing I want to say about Congress is that lobbying in Congress, the political process writ large, is probably even less representative than it is in other types of contexts. I think Congress does less of a good job, or the parties that lobby Congress do less of a good job of aggregating the total sum of social interests than they do in other, with regard to other questions of law or public policy. So generally speaking, large firms, the Microsofts and Googles of the world, not to mention biotechnology companies, they do a reasonably good job of exerting pressure on Congress, but there is no comparable mechanism for individual consumers to do so. Some of it gets done in certain small areas, like the AARP cares about drug costs, and the AARP is obviously very powerful, but there is no public interest organization for the assembled consumers of smartphones to express their preferences about the price of smartphones versus innovation in the smartphone field. Organized nonprofits largely do not exist when it comes to patent law. You just don't see a sort of, a lobbying group that represents consumers or that represents disaggregated individuals the way you do in lots of other areas. There's no equivalent to the Sierra Club, the National Rifle Association, labor unions, et cetera, that exist simply to amalgamate these types of individual preferences and express them in a way that will be significant in Congress. And of course, we can, as individuals, make political contributions, but we make a political contribution to some representative. We're buying a package of things. That contribution is binds up IP and lots of other issues. And so it's very hard to express a meaningful preference to a representative that's simply about IP. It's funny, there are these groups. There's an organization called the Coalition for Affordable Drugs. There are groups like that sound like they should be sort of aggregators of individual preferences. The Coalition for Affordable Drugs is Kyle Bass's hedge funded organization that exists to challenge drug patents that he has shorted so as to try to make money in the markets. So I mean, that might be a terrific thing generally, but that's not a good way to accumulate individual preferences. Okay. And lastly, I guess I would say a lot of the costs are hidden even to the consumers because of the way that the marketplace is set up. So for instance, if you're paying for drugs, you might not understand the effect of patents on drug prices because it's covered by insurance and you don't realize that those prices are being reflected in the premiums you're paying because the copay seems so small. And so I guess what I want to say about all this is that I think that to the extent that Congress is even trying to engage in a social welfare calculation, it's missing a broad swath of the universe. It's missing a broader swath of the universe than it does when it comes to other types of social issues where people have better and more effective ways of expressing their preferences. So what would the alternative look like? So quadratic voting gets at lots of these issues. And of course, quadratic voting is not perfect either, because among other things, if people don't quite understand the effect that a patent will have on them, it's hard for them to cast a meaningful vote on it. But at least it will have the effect of aggregating lots of these preferences in a useful and usable way. And again, I think that problem of disaggregation is more severe here than it is in lots of other fields. So again, number one, obviously, it aggregates the preferences of these dispersed consumers. You could have a quadratic vote in which everyone gets to participate, and people could express their views about whether they want lower drug prices or how they feel about the trade-off between lower drug prices and more innovation, or likewise in other sorts of industries. Of course, parties can vote the strengths of their preferences. And it provides a mechanism for ascertaining value placed on goods that don't exist yet. Quadratic voting is sort of like the best of revealed preferences, or it's some happy combination of revealed preferences plus contingent valuation surveys, because here is actually a way of getting people to state a preference for a good that they don't have yet. It's not revealed preferences, it's not being traded in a market, but they're actually putting real dollars on it, so it's not like a contingent valuation survey where they can just name any amount of money they want, subject to a weak budget constraint, and thereby sort of subvert the purpose of the study. They're putting actual dollars down on something that doesn't exist. It's a pretty nice mechanism for getting at what their underlying preferences might be. More to the point, you can get sort of firm by firm information and the expertise of these individual firms on both the economic and the technical issues underlying these patents. So, it might be that a typical firm that's in writing software and working in the software industry doesn't know exactly what the effects of software patents on that firm will be, but it's undoubtedly the case that that firm will have better information about it than a court or even the Patent and Trademark Office will ever be able to assemble. And of course, this will also allow aggregation of secret information on licensing behavior, which is essential. So you'll get firms that will have incentives to report effectively what's going on behind the scenes that cannot be observed by any of the other public institutions that might think about weighing in on patent policy. And of course, we could tailor these sorts of questions industry by industry, whereas the courts have been very reluctant to engage in industry-specific patent lawmaking. You can imagine patent quadratic voting questions that would act industry by industry if we wanted them to be. So that's sort of the basic framework. I think that there are all these other sorts of nice features of using quadratic voting in the IP context related to some of the issues that have come up yesterday and today. So to start with agenda setting. So a lot of these issues could be framed as binary choices. You can imagine, a question to be voted on that was just sort of, should we allow patents on X or Y? Should technology X be patentable, yes or no? Or you can rewrite them in terms of multiple options if you wanted to. Should the patent term for X be 5, 10, or 20 years? But in addition, we have this sort of natural, neutral, or at least relatively neutral, built-in agenda-setting body, the Federal Circuit, the courts more generally. So you could imagine a system in which it was the courts who got to decide when these votes would actually take place and the issues that would be voted on. So you could have Congress giving the courts the authority to basically certify questions for quadratic voting, much in the way that that right now federal courts are allowed to certify questions to state Supreme Courts. So if a federal court gets a question that's really an issue of state law and it doesn't know the answer, it can send that question to the state courts and ask them for their opinion on that issue. And so you can imagine the same thing here. The Federal Circuit, Court of Appeals, or the US Supreme Court gets this particularly sticky question of patent law, and that court could just simply certify the issue for a quadratic vote. And you might even imagine automatic mechanisms that would do the same thing. So for instance, if there's ever an issue that reaches the Federal Circuit and that court is divided by a certain margin, let's say if they're divided, there are 12 members of the court, if they're divided 8-4 or 7-5 or 6-6, the issue automatically gets sent out for quadratic voting instead. Now, there are obviously problems about constitutionality of all this, which Eric and Nick described earlier this morning. You could imagine these votes as actual binding legal votes, or you could imagine them as just sort of advisory votes where you're taking essentially a public referendum on the question, which might not be technically binding, but would exert enormous influence on the courts to adopt the answer that was determined in the quadratic vote as their own answer to the legal question. And then, of course, in the end, you could just hold votes pursuant to legislation. And I think, the picture is that everyone would be able to vote, individuals and corporations. So every legal person would be allowed to vote in these sorts of elections. So individuals could vote their preferences as consumers, and corporations could vote their preferences as producers or consumers of this intellectual property as well. So you'd have an election that involved not just human beings, but corporate entities too. And that may raise a whole host of other sorts of issues, which we can talk about if you'd like. Lastly, a word about implementation. So there is always this question, at least I think it's interesting to explore the question about whether the entrenched interests that are largely in control of the political process as it applies to intellectual property and patent law right now would be interested in relinquishing that control. So if you are Microsoft, or if you're Pfizer, you might like the fact that you have a pretty loud voice in Congress and your consumers have a somewhat quieter voice, and you might not want to turn things over to a quadratic vote in which those consumers are able to express their own preferences. I think that these are sort of important issues which Eric brought up in earlier work about kind of about systemic institutional change more generally, but I think that they're nicely ameliorated, at least in the context of quadratic voting. So the alternatives are pretty unsatisfying. If you are, if you're Pfizer, if you're Microsoft, it's nice to have influence in Congress, but for all that influence, Congress is not the party that's acting most frequently. It's really the courts that are doing most of the work in patent law, and they don't like the outcomes they're getting in the courts. They're uncertain, they're often economically incoherent, and so there might be a nice push for alternatives. In addition, the switch to quadratic voting is going to create a lot of uncertainty about what the outcome is going to be. I'm not sure anyone could necessarily predict what precisely will happen, partly because, as I've said, the largely excluded group of consumers has divided interests. On the one hand, they want more innovation, but on the other hand, they probably want lower prices. And so the way in which that type of vote will work out is a matter of question, I think, for a lot of people as well. And so that uncertainty might create space for political bargaining. No obvious winners or losers, so no obvious firms who would lobby extraordinarily aggressively against this proposal or for it, for that matter. And of course, optimistically, parties might all believe that they would win. OK, so I'm done. I'll take questions now.
That the first 14 slides meant that this was a really bad case for quadratic voting rather than a really good one. And it basically has to do with all the information complexity. Even the firms can't figure out. Consumers have no frickin' idea what helps and what hurts them. It's hidden. It's changing over time. It varies by industry. You might be on one side one day the other day. Even if you had all the research from yesterday and the best people to interpret it, since we know technology tomorrow might be completely different, the courts might get it wrong. For all those reasons, almost all the voters aren't going to know what to vote. The firms might, but of course there's massive externality just in the most simple plain vanilla pitching in this particular area. Let's just say we have, one group of firms that patents and they sell to customers, a very reduced form model. In that world, we have the interest of the firms on one side, the consumers on the others. The firms know, the consumers don't know. So we then tee it up to this broad vote. So, and since you especially emphasize the consumers have no idea what's going on, but they're suffering huge amounts of the effects, and their small votes of moderate amounts will collectively be a large amount, because we know that a lot of the consumer surplus is sort of what's at stake here ultimately. And then just to merge that with another point, you're assuming that the courts and agencies can't figure this out. Part of their inability to figure it out, so let's just take courts, but agencies could do it in other ways. Courts cannot get, we're assuming, credible amicus briefs from, say, academics or others who aren't in the pockets of industry. Agencies can't, like various agencies do, and the EPA and NASH and others, assemble panels over time to pull in information. We're assuming that the best they can do for that is not sufficient for them to figure it out. And again, if all the bottom line, all the surplus hits were on mostly the 100 sophisticated players, and they knew and it was hard to extract, then quadratic voting would be a good answer. But if we think that their interests are often going to be systematically the opposite of everybody else's interests, and everybody else's interests will often be larger and in the opposite direction, but they're going to be completely ignorant, then I think we have a real problem. So I have another topic, but I'll just stop there for now. So that.
Sure. I guess I should say, I don't think that consumers will be completely unable to figure out what it is that they want, or will be flipping coins or anything else. I think that consumer preferences can diverge from person to person pretty dramatically, and it's probably hard for an outsider to figure out what that consumer wants. And I fully acknowledge that it might be difficult for consumers to know exactly what the effects of a particular change in law will be. But I think that they can at least express sort of their preferences at a pretty high level of abstraction about a given issue, better than these other possible institutions.
When the referendum is on patentability of cDNA, how does that election go?
Well,
how
in
do
what respect?
consumers figure out whether they're for it or against it? It's going to be based on very long-run effects on inducing certain research, but it's a clog in the process and all of this. Consumers are first order. They're almost all of the voters in this world. What do they do?
Well, look,
you said that the courts couldn't figure it out. The agencies can't even figure out what's in the consumer interest, is what you said on the first slides.
So look, again, if the consumers don't know or have no idea, then maybe they're not going to participate in the quadratic vote in the same way, right? I'm not imagining that they'd be obligated to do so.
The huge attacks on Congress was the industry has all the influence and the consumers aren't there. We now move to quadratic voting where none of the consumers vote because they don't know what to do. Now it may be that we get a better representation of industry and less costly way, but I'm finding a lack of nexus in a sense between much of what was on the first 15 slides and what was being proposed.
Okay, so look, but part of it is, of course, that, so when I say that, firms have influence in Congress and consumers do not, right, that also goes for certain types of firms versus others, right? If you're a startup, if you're a smaller biotech firm, whatever else, you're going to influence Congress a lot less than the larger firms. Those issues are, those issues are just on top of all of the other reasons why quadratic voting is better than allowing the typical political process to play out in Congress.
All the startups that don't exist yet.
Sorry?
All the startups who don't exist yet, and the people who don't know that, how are they? It's pretty imperfect.
True. Although again, to the same.
Once you're a startup, you have a lot. You're already an incumbent who's maybe already got IP. Again, all I would say when I flipped through the paper when I heard the presentation, I'm seeing almost zero attention to the question of what's at the end the solution to what's.
Look, I think if the question is quadratic voting going to solve all the problems in patent law, or is it a perfect solution that will allow us to, get to, obviously wealth maximizing outcomes? The answer is, of course, no. It's a purely comparative point in light of the other alternatives that are available to us. So if you're Congress, and you're being influenced by just a few larger players without this broader picture of what's going on, that's surely inferior to some sort of quadratic vote in which, even the venture capital firm that might want to invest in a sector down the road, they're more likely to participate in that quadratic vote than they are to have some voice in Congress and lobbying about that particular issue at this point.
You need to have a more sense of exactly what you have in mind. So I just couldn't get a sense. So are the voters going to vote on whether Apple violated Samsung's patent or vice versa? Is that what you're imagining? Or is it the proper patent term is 15 years or 20 years and we should have injunctions versus mandatory licensing? Or are those the issues? I didn't have quite a sense of what you intend.
Yeah, okay, so it's the latter, it's the second set of issues. It wouldn't necessarily be not something, so I mean, those issues of course might influence just did Apple violate Samsung's patent, but it could be something much broader than that, like, you know, should Apple be allowed to patent, you know, the particular piece of software that they were using to sue Samsung, or even more broadly than that, certainly more broadly than that, should that type of software be patentable in the first instance? Should CDNA be patentable?
Should technology, so and you take the general public like 300 million people then voting on these topical issues? Just having that quite in my head.
Well, I mean, again, I think that there will be lots of people who won't have an opinion or won't have an answer, won't have a view, and then simply won't vote at all. And so what you're going to get...
There's thousands of these technologies. So every year there's like a book that comes out. So here's the 1,000. Which one do you want to come in?
No. I mean, again, this is an agenda setting point. You know, I think there are sort of central issues of patent law that come up in the courts. The courts look at those issues and try to sort through them and struggle to figure out whether what they should do with that issue because they don't know how to think about the question economically. And so the court reaches some conclusion, but instead of the court reaching that conclusion, it could be put to a quadratic vote. So, you know, if you counted up the number of Supreme Court patent cases every year, that could be a rough estimate of the number of quadratic voted patent cases that we would see each year. And again, I mean, look, obviously there are going to be people who are low information voters and won't necessarily know what to do or have an opinion about it. That problem is present in any of these sorts of, that problem is present in people who elected Congress, that problem is present in any sort of public system of voting here. I think that the point that I care about is that those, you know, a lot of these players have information that's not being aggregated in the current institutional mechanisms that we have. Yeah.
Well, this is a slight variation on an actual question. But suppose I want to do a latent discriminant analysis of engrams in DARI texts. Okay. How are we going to get a reasonable vote on that?
Sorry, what are we doing? We're doing latent.
I want to patent latent discriminant analysis of engrams in DARI text. Well, is that reasonable, or should it be Farsi text? Or maybe it should be alphabets as opposed to ideograms? I mean, and why latent discriminant analysis? I mean, why not principal component analysis? I mean, how are people even going to analyze and present these kind of questions in an election?
I mean, I see the point. Those are not the sorts of questions that anyone is deciding right now in the world of patent law, right?
On almost exactly what I said.
Absolutely, but those are not the sort of baseline legal questions that make their way up to the Federal Court of Appeals.
Circuit splits is sort of a possible
Yeah.
agenda setter. There are federal circuit splits in cases just like this kind of all the time.
Oh, but I mean,
So, but
Not,
you're saying that
not,
you're taking back
no. That's actually not true. I mean, not en banc federal circuit splits. I mean, I'm talking about a court, not every single federal circuit case, right? And those again.
I'm actually getting at a real point here because you're not allowed to patent mathematical algebra techniques.
Right.
But you can actually do it by patenting every example.
Right. Well, there's a separate question about whether those patents are actually going to be valid if they ever get in front of a court. But
Well, it was defended successfully in court.
But my point is that those are not the sorts of questions that the Supreme Court and the Federal Circuit are deciding as a matter of sort of national policy right now. Those are not the sorts of questions that the Patent and Trademark Office is making rules about either. So I agree that it's hard to know what to do with those types of questions. But again, it's not clear that that would necessarily be a bad thing. If that were the question on the agenda, everyone looks at that and says, I have no idea what to think about this. I'm going to sit this one out. And only the few players who know something about that issue or are interested in it enter the quadratic vote, and those few players are then accumulating their information in a way that that's much better than if it went to a court.
This issue was actually touched upon earlier when we talked about splitting up votes and putting in lots of little things.
Mm-hmm.
I mean, I can completely subvert the intent of the law and effectively patent a mathematical technique by splitting it up in every little separate case, right? And under quadratic voting, that would be a very clever thing for me to do. And with software-defined, software written and issued patents, I can crank out 1 million. I can lock down that technique.
I'm sorry, I'm just not sure I understand the point. If the technology is unpatentable, it's unpatentable whether you separate it into 1 million parts or. it's not clear that those examples are patentable either under current law. But the point is, I'm not sure that has anything to do with quadratic voting, because you can currently, as things stand, you can file 1 million patents on those things, and that's perfectly fine. And those patents, maybe they'd get adjudicated, one after another until you reached 1 million, or maybe they wouldn't. But regardless of that, you could try to file for those applications and get them. The question is, when a sort of a central question of patent law reaches a high enough threshold that it gets promoted to the full Court of Appeals sitting together, or the Supreme Court, who's going to make that decision? Now, though they're not going to be deciding on each one of those million sorts of patents, they're going to be deciding on larger, more central questions of patent law. So I'm just not sure that example is necessarily relevant to the particular decision about which institutional actor is going to be negotiating these. Eric.
So, we could think of lots of different sort of institutional solutions to this problem. And so, the two that occur to me, one is just like a referendum, right? And I think, obviously the objections to a referendum, the objections to your system would apply to a referendum as well. But you could sort of see somebody might have thought of that as a solution. And then the other is industry standard setting processes, which are very common. And so the problem with the referendum is that people don't know anything, consumers don't know anything. And in the industry standard setting process, they're excluded. But then we're going to be worried that the people, even on both sides of the license, the IP, are going to make a deal that hurts the consumer. So the basic problem seems to be a combination of is basically consumer ignorance, right? That's the basic problem, right? So wouldn't the solution be something like industry standard setting, but with an agency that's that represents the consumers. So the agency would be like one of the participants it would be a government agency, but it wouldn't be making the rules. It would be negotiating with these other guys, and its job would be to try to take the position of the consumers, but it would have enough sophistication that it would be able to figure out. I mean, it knows what the consumers want. They want low prices over the long run. There's not really anything else they want, and so
More innovation.
Well, but that's part of it, right? More innovation means lower prices for whatever it is that we like cars or spaceships.
Right.
Or whatever. But how about that as the starting point? Look, in a way, that would be. I mean, I'm just trying to. I think the problem is the basic problem that quadratic voting I don't think is solving in this context, or might not solve, is this kind of basic ignorance among consumers.
Okay, so I think a lot depends on what you mean by an industry standard setting procedure. So right now, when industry groups get together to set standards, they're not doing anything that's relevant to who owns what intellectual property or who will have to license from whom. They're just sort of deciding, when we broadcast something on a Wi-Fi spectrum, we're all going to broadcast it at this frequency. Or, when you plug your thumb drive into the computer, it's going to, all the USB ports are going to operate in a particular way. If you ask them to decide, how strong should the patents be, and how much should each company have to pay another in royalties, they're never going to agree about that because they have widely. Why wouldn't they agree? Well, because there will be. Well, let's put it this way. I mean, in theory, you could imagine striking a bargain among all of these different interests, but it's an enormously high transaction cost environment. You have hundreds or thousands of players, all who have differing interests, and it's without some, if it's just pure negotiation, it's going to be very hard for them to agree on something. You could then put it to a vote. So you could imagine, a quadratic vote within an industry group about the set of royalties that will be paid among the members in that industry group. So you could imagine a quadratic vote that's confined only to sort of producer side entities within a particular technology field. And then if you think that consumers are ignorant, which again, I'm not sure is the basic problem here exactly. I think that part of the basic problem, at least as concerning public institutions, is that they don't have information.
The skepticism that you're getting, starting with Lewis, is this idea that consumers could have any idea. I mean, it's not just that they don't know whether 14 or 20 years is optimal. They don't even know, whether they think innovation is good or not. I mean, they don't care about innovation in the abstract. They care about the goods and services that are coming down the line. And if there's less innovation but lower prices, that's fine at some level. And That seems to be the core problem.
Okay, so I mean, again, I think it's there is more to innovation than just lower prices also, right? Some people will be satisfied with their range of product options and just want them at lower prices. Other people, if you have a disease that's not being adequately treated by the drugs that are currently available to you, that person wants greater innovation in that sector, not just lower prices for the currently existing products. So, I mean, there will be people who have interests like that they can express in some kind of voting mechanism that they might not be able to express otherwise. But look, I don't mean to fight your example that strenuously. You could imagine a quadratic vote within an industry group in which those are the people who are participating in the quadratic vote as a way of deciding, amalgamating the preferences of those industry players within that technological subfield, and then having some sort of outside constraint imposed by an agency that exists to represent consumer interests, or knows something about what's best for the consumers and that comes in and only approves a certain set of outcomes, or an agency that votes in the interest of the public or something like that, so it gets a certain budget that it's allowed to express on the behalf of the public. Which is why again, the point I want to stress is it's not just about consumers and their ignorance as to whether certain changes in the law will be good for them. It's also about the fact that there's a lot of information held internally in these firms that is very hard for an agency or a court or Congress to access. And so you'd like to have a mechanism that allows those firms to express those preferences in a meaningful sort of way, or like in a balanced sort of way. Ben.
So I wanted to shift gears entirely and ask about the corporations getting to vote. Mm-hmm. And part of the thought here was, so I'm not sure what function that's playing. I mean, I understand that you're looking at a certain problem and you're trying to fix it in a certain context. And I don't want to be flat-footed about this, but the function, the idea is that QV is tracking the intensity of preferences with the goal of maximizing welfare, achieving something closer to that than other ways of doing things. I mean, here's a flat-footed thought. Corporations don't have preferences in the relevant sense. They certainly don't have welfare in the relevant sense. I mean, why isn't it sufficient for the people who own the corporations and are shareholders or employed by the corporations to cast votes? I mean, it doesn't, they have interests, they have preferences. I mean, and then in connection with, I mean, it does seem like if you go the corporation route, you're obviously going to have to put constraints on that. I mean, here's a fact you probably don't know about me. I own 3 corporations. This is true. The 3 shell corporations were formed with my name on them. It took me a total of literally 2 minutes per corporation. It was in connection with the friends. I mean,
You did that in order to be able to make this statement.
Yes, exactly.
Right.
I knew it would come.
Well,
right now I'm making 5 more.
You're preparing yourself for a day when all of your corporations can vote. You're going to clone yourself via corporate entities.
I mean, obviously you could put constraints on this, I suppose, but I mean, it brings out the artificiality of, I mean, these, and then, I mean, I mean, now with the quadratic function especially, I mean, on the vote purchasing. So, I mean, there are problems with the artificiality. They don't seem to play the role. So I'm just wondering, what is the rationale for having them voting along with consumers, say?
Okay, so, I mean, you're right that the corporation is nothing more than the assembly of the interests of the people who own the corporation. So, in theory, you could just have all the stockholders voting their interests in the same way. I guess I feel like, if we're worried about consumers sort of not knowing where they stand and not knowing exactly what they're in favor of or against, I would think that problem for stockholders would be magnified substantially. And so they're just not going to understand which side of all the, most people don't know which stocks they even own. If they're doing it right, especially, they shouldn't know which stocks they own. And so they are not going to know which side of all these arrangements they're on. And so, we can push things up a level and use the corporation. And the corporation is, the corporation in this world is standing in for, Eric's consumer-focused agency, where you're going to amalgamate the interests of a lot of dispersed people who don't quite know what those interests are under the roof of one particular interest that does understand all of those preferences. Now, the problem that you're describing about the shell corporations and everything, this is just the same sort of collusion and gaming problem that people have discussed for a day and a half now when it comes to quadratic voting. So I don't think I have a lot more to say about that. But yeah, you'd have to obviously police that some corporation didn't set up 15 subs and then have all those subs vote that interest so as to assume more power. Glenn.
So just along the constructive lines Eric was going along, and to sort of address Lewis's question, maybe a more near-term way of implementing this would be to use various forms of quadratic voting for information gathering in very distinct aspects of a problem that might then inform courts. So like, for example, one context in which CDE is doing a lot of work is on new product development for corporations. A very similar technique presumably could be used to inform questions like you were describing about the trade-off between new product development and the reduction in prices of existing products. That's something that I think, like, probably in a year we could have a tool that would do that sort of thing. It's not, and that would probably be reasonably well accepted, even by someone like Lewis, because that's something consumers might well know
It
about.
could then feed an agency.
Yeah,
or-
Yeah, and by the way, there could be other aspects. So, for example, imagine you wanted to have a lot of people have suggested peer review mechanisms for patent approvals or some form of that. You might want to do that, and you might want to give currency to a panel of peers who would then review a number of applications, and they could be used on that. And then the standard setting thing could be used there too. And all those things might be separate inputs, all of which are informative, useful inputs into an eventual decision that's made by either an agency doing a cost-benefit analysis or a court. Or it could even be a poll that would then go eventually to a quadratic vote. But people would have this polling information that would be useful in helping inform them about the decision. Or just a thought.
Okay, great, thank you. I take the point, and I take the point that if this becomes unworkable or unuseful on a larger scale, there might be smaller scales in which it might be useful nonetheless. Lewis.
Just a mechanical comment, partly inspired by some of the other comments. So in thinking of prior discussions, especially about the splitting issue. So, you said, well, corporation, we have to police their setting up. Of course, many just, for various reasons, are organized in different ways, and we have to decide who can vote, and counts as separate, and we have to. But I would think that a primary manifestation, and it's not obviously this is a bad thing rather than a good thing, but just sort of descriptive when we think what's going to happen. So like, I'm Microsoft, and like I want to vote, and it goes with the square. So if I want to cast 1 million votes, this is getting expensive pretty quickly.
Yeah.
And like, even we, Microsoft, can't afford that. On the other hand, I can ask 50,000 employees to, by the way, you sort of sequence 2 memos. We've just increased everyone's Christmas bonus by $25. And we'd like you all, and no one's going to ask and no one can tell it, it's all secret, to spend $25 voting this way, on this proposition. Now, if it turned out on one hand that the correlation, say, between number of employees or number of employees who would listen, to the strength of interest intensity and the like was a pretty good correlation, we would then actually be getting the revelation that we wanted in the first place. I mean, being purely instrumental in this. On the other hand, if a lot of those with the highest valuation, say, have very few employees, they've got really valuable stuff and few employees, and there's a lot of established folks who have lower valuations and large number of employees. So it would turn out that the practical manifestation of informed and significant number of votes would be driven by these features of the environment. So in thinking about, again, and going back to like Glenn's modification, if one's trying to develop an elicitation mechanism to feed into a process, maybe actually like a general quadratic vote where anyone can vote is not what you want. Maybe you'd actually want it to be the corporations voting. As corporations, you would design it in a certain way, you would do your elicitation, you'd think you'd have learned what you could from that group, and then that would feed in, and you would be using it just as that. And actually the more democratic version of it would be neither the informed vote nor but it would have these particular circumstantial features of who is in a position to non-trivially influence others that we might decide are inferior. So actually going even more, let's embrace the corporation idea. That's the information we actually want. Let's design something that actually gets that information in the most useful way and feeds the process.
Okay, great. Thank you. That's helpful. I mean, I suspect that in a lot of contexts, but certainly not all of them, there will be a positive correlation between the size of the entity and the size, the intensity of its preferences. Right, exactly.
But if it's noisy, but the entity is actually much less noisy, than the pure corporate version.
Right.
Yeah, they're not real people and they're not in our welfare structure, but they're actually the better way to reveal the information that we want revealed to make the decision.
Right, and I mean, you'd also probably, obviously the corporation, the people who you'd then be restricting from voting would be labor in the corporation as opposed to necessarily owners who might have, maybe partial owners depending on whether they own equity as well, and they have different interests, and so there might be something getting lost there. But it also could very well be that, the interests of labor and capital in a particular corporation are heavily correlated when it comes to external questions of what the law or policy governing that corporation could be. So I'm with you on all of that, and I think that's very helpful. I guess the only other thing I would say is, those subsequent memos, you could imagine that in a world where we're using quadratic voting on anything. Smith and, we're going to take a quadratic voting on gun control, and Smith and Wesson sends out, 2 memos. Yeah, right. Right, or well, the memo of, your...
Microsoft needs to send a memo because the employees may not know which way to vote.
Well, possibly. Although the memo that says, your quarterly bonus is going up, by the way, your quarterly bonus is going up will still be an important memo and, presumably one you want to try to avoid regardless of what question we're voting on.
If you restricted your voting group to corporations along the lines that we're talking here, what if you used the chits idea instead of the actual money idea? So that the idea was that you get to be a voter you get to be a citizen of this kind of vote by passing some kind of a threshold. So we get rid of the splitting problem. And once you've achieved a certain threshold, then you get the right to X number of chits. Now, maybe those X number of chits would be just the same number for every corporation. Every citizen is the same in this world. Maybe they would be specific to the number of employees or something else. But that would at least give you a way to try to block right away the problem of these splitting off, so that you don't get an automatic vote because you're a corporation. You actually have to somehow pass a threshold.
Yeah, I could imagine that. I mean, I could imagine that also. Especially if what we're talking about is corporations voting, it seems maybe less necessary to use credits than it does in other contexts, just because we ask corporations to spend money in support of or not support of various things all the time, and so we don't have the same sorts of concerns about whether we're violating rules against making voting depend on wealth or anything else. And it's not clear whether the budget constraint imposed by sending out a fixed number of credits would be necessarily the right idea. But I take the point that it will solve some of the collusion problems, and possibly if you were spreading, if you told a corporation you had a fixed budget of some sort, I guess you could make that budget depend on the market capitalization of the corporation as well, and they could spend it across a whole series of particular policy questions, then that might work.
I think you want to be more resistant to some of the further, which is, you really want to know whether Microsoft cares $1 billion or $10 billion.
Yeah.
And like, these intensity things are really important. So all corporations are equal or all across contexts. It seems that may be losing precisely the information you want. And here, getting the 20 most intense people right and knowing the actual magnitudes is first order to figuring out what the good policy should be. And we also imagine massive and order of magnitude variations across players that might look superficially similar in what the actual thing is. And also I think that the chip system, if you're from corporations, that it's not clear that doesn't make splitting, also extremely attractive. Even more. 15 rather than 1, I have 15 times as many chips.
Well, I think the idea was
quadratic voting also gives you that incentive because of the cheapness of the voting, but I think you still have pretty big incentives. Or if my employees got chips, going back to my comment before, then the number of employees in the same way would be doing.
Yeah, I mean, I think the idea was to at least create a threshold for receiving credits in this game such that it would diminish the ability to split yourself and game the system that way. But of course, that would depend a lot on how high that threshold was set and how easily these companies would be divided.
Venture funds, if we think a lot of the value is in small entities and that we don't even know quite how to measure it, one has to keep track that these big information questions that we're really trying to elicit, we don't want to crush too much of that in the process of coming up with an add-on that works.
I agree.
We're out of time. Thanks so much.